Hey y'all, welcome back to the Loud Little Ducky. Today we are discussing a new filing in the DVRO renewal, Owens versus Marraccini, and attorney for Mike Marraccini, Omar Serrato, has put in his motion to dismiss. In other words, dismiss this filing, dismiss this case with none of this. While that would be great, I think that for like discovery or for Owens being referred for prosecution and a judge seeing everything, I almost think it needs to not be dismissed. And I kind of want to see Owens testify and Omar cross her. So, I mean, that's for my entertainment level, but dismissal would be great. And Omar is doing his job as an attorney. He wouldn't be doing his job if he did not do this. So, props for being professional and not giving in to just letting us have some entertainment. But let's see what unfolds here. Let's get quacking. So, here we have a motion to dismiss against Laura Owens. And this is a request for that order. Saying right now that the court hearing will be October 21st, 2025 at 8:30 a.m., which will be a belated birthday present for me if she gets referred for prosecution in California. That would be so nice. And if David Gingras got disbarred. And third page, nothing. Fourth page has other orders requested as motion to dismiss under 47.3b and D. Facts to support. They're saying, please see attached. Dated September 11th, 2025, Omar Serrato. So this was submitted a while ago, before Owens' former attorney, David Gingras, had even talked to Omar. He had done this. Okay, so here we are. As I said, written by Omar Serrato. These are his and Marraccini's words. This is the motion to dismiss DVRO pursuant to CCP 47.3b(d) and D. Notice of intent to seek sanctions pursuant to 271. And something that I like in California that I didn't see in Arizona and I haven't seen in some other states, and maybe it's just a stylistic preference, but I noticed that Gingras did it. No, I don't know if Gingras did it or not, because Omar is the one who submitted it. But Gingras's did have this. So the little thing at the bottom where it's got the page number and then it has motion to vacate 2018 DVRO pursuant to CCP 473. I like that it has what page it is and what it belongs to on the bottom of each page. I just like it and appreciate it. So, introduction. Respondent Michael Marraccini moves to vacate the domestic violence restraining order obtained by petitioner Laura Owens in January 2018 on the grounds that the order was procured through fraud. Okay, so maybe I don't need this to go to trial, although the cross-examination would still be nice. But this isn't necessarily a motion to just get rid of the current renewal. It is a motion to vacate the entire thing starting in 2018 when Laura started this bullshit with Marraccini. So, what has become abundantly clear from all filings addressing Owens' requested renewal for the underlying DVRO is one fundamental truth. Laura Owens will not be able to refute evidence based on Owens' admissions, independent witness statements, findings from separate court proceedings, a recent felony indictment for fraudulent schemes, perjury, and submitting false evidence, which proves Owens' fabrication of allegations of abuse, and the presentation of false evidence to obtain the 2018 restraining order. In doing so, Owens deprived Marraccini of a fair opportunity to defend against the DVRO, satisfying the definition of extrinsic fraud that warrants equitable relief. Yeah. Notice we've seen no filings from her yet. Or since the beginning, basically. Marraccini compelled by the concealment of material facts Laura Owens' scheme stipulated to the DVRO. He now stands resolute in asking this court to vacate the fraudulently obtained order in the interest of justice, ending a 7-year-old prejudicial restraint on his freedoms, on his liberties, that Owens has used to taunt him wherever he goes. Owens' CPAD and animosity, the unearned robes afforded to genuine victims of abuse and criminal intent, has sought Marraccini out to affect his life in any possible way. Marraccini has moved on. He started a family with a beautiful wife and children. He has lived a crime-free life full of love and affection from those he actively supports. He moved on in every imaginable capacity, but for Owen's criminally inspired request to grasp at the ghosts of the relationship she relentlessly coveted, that Marraccini wants to erase from his existence. CCP 43 affords him that opportunity. Factual and procedural background. Owens and Marraccini were in an on-again, off-again relationship from 2016 until mid-2017. On January 7, 2018, an incident occurred in which Owens confronted Marraccini and his sister in public, screaming accusations at Marraccini, prompting him to ultimately call the police to defuse the situation. See Exhibit A, San Francisco Police Report Follow-Up Card. And the one that we saw in Omar's last motion, where it was the picture of all the cops outside the door. That's what he's referring to. 2 days later, on January 9th, 2018, Owens filed a request for a domestic violence restraining order in this court. Case number, which the court granted on a temporary basis on January 10th, 2018. It was an ex parte. Owens' application for the DVRO alleged that Marraccini subjected her to extreme physical and emotional violence over the course of their relationship. Owens submitted photographs of injuries that she claimed were caused by Marraccini's abuse, when in fact, those photos were from an unrelated accident. Owens falling off a horse. See footnote 1. In 2018, Owens submitted 4 photographs to this court in support of her declaration. February 2017 photographs, 2 photographs purporting to show bruises on Owen's arm, are dated February 18th, 2017. During that same month, Owens competed in 3 horse shows, including one held from February 15th through the 19th in 2017. March 2017 photograph, a third photo depicting redness around Owen's eye, is loosely dated March 2017. That month, she competed in 2 horse shows: the Winter Equestrian Festival, March 15th through the 19th, 2017, and the Blenheim Spring Classic, March 29th through April 2nd, 2017. May 2017 photograph, a 4th photograph showing redness around Owen's eyes and cheeks, is loosely dated May 2017. In that month, she competed in 3 horse shows: a Del Mar National Horse Show, the Sonoma Horse Park Spring Classic, and the Central California Classic. Despite Owen's extensive allegations of abuse, these 4 photographs constituted the entirety of her photographic evidence. Exhibit D, public information showing Owens participated in horse events. Okay. Okay. I'm okay. So she was in these horse things, but were all these pictures from riding horses? Uh, I don't know. I'm gonna need this wrapped up for me. Okay. Owens submitted the photographs of injuries that she claimed were caused by Marraccini. Okay, falling off a horse. Owens also claimed the abuse was so severe it drove her to seek inpatient psychiatric treatment, a claim which she herself had contradicted in prior filings. Exhibit B, text messages regarding inpatient psychiatric therapy. Exhibit C, declaration of Laura Owens, March 29th, 2018. Marraccini categorically denied Owens' allegations. On January 22, 2018, Marraccini filed his DV 120 response, refuting every claim and alerting the court to Owens' history of manipulative conduct, including instances where Owens had fabricated pregnancies and made conflicting medical claims during their relationship. Both parties submitted additional declarations and some third-party witness statements in preparation for an evidentiary hearing on the DVRO. The evidentiary hearing, originally set for January 26, 2018, was continued to allow discovery, including depositions of the parties and further evidence gathering. By July 2018, Marraccini was emotionally and financially exhausted due to the petitioner's barrage of false narratives. Rather than continuing to engage with what he knew were baseless accusations, Marraccini made the practical decision to resolve the matter by stipulation. On or about July 10, 2018, Marraccini, simply wishing to move on, agreed to enter into a stipulated restraining order, resulting in the issuance of a 2-year DVRO through July 10, 2020, with no admissions of wrongdoing and no factual findings against him. In 2018, DVRO was issued without any finding that Marraccini committed domestic violence. The July 28th 2018 stipulated DVRO was set to expire on July 10th, 2020. On that date, petitioner Owens sought a renewal of the restraining order for an additional 5 years. The court granted petitioner's renewal request on September 11th, 2020. Extending the DVRO to July 10th, 2025. Petitioner has since treated the existence of the DVRO as a tool to bolster her self-portrayal as a domestic violence survivor, quote unquote. She is not a DV survivor. Between 2021 and 2024, petitioner made multiple public statements referencing the restraining order and accusing Marraccini of heinous abuse, including a TED Talk in January 2022, and even published essay, which was later removed due to questions about its credibility. And then he links the YouTube TED Talk video. So, yeah. Let's see what else is next. In 2021 through 2023, petitioner became involved in litigation in Arizona, where she accused at least 2 other men of abuse after falsely claiming to be pregnant with their children, strikingly similar to her modus operandi with Marraccini. In one case, Owens obtained a protective order against a man, Greg Gillespie, after he ended their relationship. Case number Exhibit D, Civil Complaint, Owens versus Gillespie. In another, she obtained a restraining order and filed a paternity suit against a former Bachelor TV show star, Clayton Echard, following an alleged twin pregnancy. These out-of-state matters culminated in June 2024, when Maricopa County Superior Court of Arizona conducted a trial on petitioner's paternity claims against Mr. Echard. In that proceeding, evidence was presented that the petitioner had never been pregnant at all, that she had fabricated evidence, including bogus positive pregnancy tests and doctored medical records, and that she had lied under oath in support of her claims. The Arizona court expressly found that petitioner Owens had provided the testimony and that her petition was fraudulent as a part of a pattern of similar, if not identical, behavior in comparison to her prior schemes. The court noted that Owens' claims were not credible and had been concocted to manipulate the targets of her accusations. Petitioner was ordered to pay over $149,000 in attorney's fees to Mr. Echard as a result of her bad faith fraudulent conduct. Exhibit E, the findings after the trial of Judge Mata. Shortly thereafter, in May 2025, petitioner was indicted by a grand jury in Arizona on 7 felony counts, including fraudulent schemes, perjury, forgery, and evidence tampering, all arising from her elaborate false pregnancy and abuse scams in the Echard matter. Exhibit F, criminal indictment. It is against this backdrop that the petitioner filed yet another request to renew her DVRO against Marraccini on or about July 10, 2025, seeking to extend the restraining order permanently as the July 2025 expiration approached. Owens' renewal request is set for a hearing in October of 2025. Marraccini has opposed the renewal and now additionally brings an immediate motion to vacate the original DVRO on grounds of extrinsic fraud, citing newly discovered evidence that was unavailable at the time of the 2018 stipulation. New evidence of extrinsic fraud, including unknown evidence from the 2018 stipulation, allows this court to vacate the 2018 orders that have been obtained through mistake or excusable neglect. based on what is now known to be Laura Owen's fraudulent scheme, perfected over the course of nearly a decade. The evidence now available paints a devastating picture of petitioner's lack of truthfulness and her abuse of the judicial process. Marraccini urges this court to consider the full evidentiary record, which was not available at the time of the 2018 DVRO, and to exercise its authority to vacate an order that was fundamentally built on fraud. Points and authorities. Relief under CCP 473D and equitable power. Courts have the authority to set aside void judgments or orders upon motion by either party after notice to the other party. Notice has been achieved under the instant case by virtue of Marraccini's filed response to Owens. DVRO renewal request filed August 25th, 2025, and through this filed motion. CCP 473 codifies the court's inherent power to vacate void judgments. In People v. 1941 Chrysler 6 Touring Sedan, the court declared that a void judgment could be set aside under California Code of Civil Procedure 473. People v. 1 National Divisified Service in Corp. versus Bernstein, the court clarified that the CCP 473 reflects the court's inherent power to address void judgments. In addition to statutory authority, courts possess inherent equitable powers to set aside judgments obtained through extrinsic fraud or mistake, even when the statutory deadlines have expired. Extrinsic fraud occurs when a party is prevented from fully participating in the case due to deception or misconduct by the opposing party, such as being kept in ignorance of the proceedings or being misled into not defending the case. Rodriguez versus Cho. The court reaffirmed that relief could be granted under equitable principles if extrinsic fraud or mistakes prevented a party from presenting their case. The court in Olivier versus Grace also highlighted that equitable relief could be sought through a motion in the original action or independent action in equity, provided the fraud or mistake was extrinsic. The distinction between extrinsic and intrinsic fraud is critical. Intrinsic fraud, such as perjury or forged evidence, and there is certainly plenty of that in this case, presented during the trial, does not warrant equitable relief because the affected party had the opportunity to address it during the proceedings. In contrast, extrinsic fraud involves circumstances that prevent a fair trial, such as lack of notice or deliberate concealment of material facts. Extrinsic fraud must relate to manner in which the judgment was procured, not the issues decided in the judgment. Hanley v. Hanley. In addition, the courts have recognized that the terms of extrinsic fraud and extrinsic mistake are broadly interpreted to encompass circumstances that deprive a party of a fair hearing, even if the circumstances do not strictly qualify as fraud or a mistake. This principle was discussed in Marriage of Park and reaffirmed in the subsequent cases. California courts have consistently articulated three-part test for granting equitable relief from a judgment on the grounds of extrinsic fraud or mistake. The moving party must demonstrate 1. A meritorious defense to the claims upon which judgment was entered. 2. A satisfactory excuse for not fully presenting that defense in the original action. And 3. Diligence in seeking relief once the fraud or mistake was discovered. Rappleyea v. Campbell. Burnett v. La Casa Donna Apartments. Goes on to say the courts have also clarified that while there is no strict deadline for filing a motion based on extrinsic fraud or mistake, the motion must be made within a reasonable time after the fraud or mistake is discovered. This requirement is closely tied to the principle of avoiding prejudice to the opposing party as highlighted in Raplia and other cases. A DVRO, though civil in nature, is a serious order, often made under expedited circumstances. The statutory framework and case law emphasizes the significant impact and purpose of DVROs in protecting individuals from abuse, as seen in the broad legislative intent to prevent domestic violence and the serious consequences of violating such orders. A DVRO obtained through extrinsic fraud may be vacated in equity. If a court finds that a restraining order was procured through deception or false evidence, the proper remedy is to set it aside, thereby preserving the integrity of the court's process. The policy favoring finality. Finality of the judgments yields to fraud that undermines the fairness of the original proceeding. The court has the authority and duty to vacate a DVRO if evidence shows it was obtained by extrinsic fraud. Yeah, this is a way to say, you know what? You made a fool of us. We stupidly believed you because we were trying to protect you, and you made a mockery of us. And for that, we're vacating this. Give Owens a tongue lashing and refer her for prosecution. Because she made California look like a bunch of dumbasses for believing her. But I'm just a mere petite little girl. Look how small I am. All these guys are so much bigger than me. Argument. Marraccini is not time barred under 473. California Code of Civil Procedure 473 provides that a motion for relief from judgment, order, or proceeding must be made within 6 months of entry of the judgment or order. This 6-month limitation is jurisdictional and cannot be extended under ordinary circumstances. However, California courts recognized an exception to this limitation in cases involving extrinsic fraud or extrinsic mistake. Weiss v. Othman. And it says extrinsic fraud occurs when a party is prevented from fully participating in the proceedings due to the opposing party's deceit or concealment of material facts. Kuhn v. Kuhn. Okay. Marraccini challenges the 2018 domestic violence restraining order under the CCP, Section 473, and contests its subsequent renewal based on the lack of litigation, absence of findings of domestic violence, and the petitioner Owens' documented history of fraudulent conduct. CCP 473, a party may seek relief from an order or judgment if it was obtained through mistake, inadvertence, surprise, or excusable neglect. The stipulated DVRO issued in 2018 was not litigated on its merits and was not agreed to under duress and exhaustion, as he was emotionally and financially drained by Owens' false allegations. The stipulated order contained no findings of domestic violence, which weakens its evidentiary basis for renewal. Although statutory relief under 473 would normally be time barred, the doctrine of extrinsic fraud applies. Marraccini did not know and could not reasonably have known that Owen's conduct rose to the level of extrinsic fraud until recently. Owen's actions deprived him of a fair opportunity to present his defense through material concealment of material facts, which satisfies the criteria for equitable relief beyond the 6 months jurisdictional bar. In such cases, no statute of limitations applies, provided the aggrieved party seeks relief within a reasonable time. On March 25, 2025, Laura Owens was indicted on 7 felony counts, including fraudulent schemes, 4 counts of perjury, forgery, and evidence tampering. Exhibit F. Marraccini is a named witness in the state of Arizona's case against Owens. The indictment represents the first official corroboration that Owens' conduct was criminal in nature, and it provided Marraccini with confirmation of the extrinsic fraud that he had previously deprived him of a fair trial. Owens sought renewal of DVRO in July 2025, and Marraccini filed his motion in September of 2025. Accordingly, the motion was brought with a reasonable time satisfying the requirements of 473. Okay. Owens' pattern of deceit constitutes extrinsic fraud. So now he's hopefully, he's been saying, all this stuff amounts to this extrinsic fraud. So here he's going to show us examples of extrinsic fraud that Owens has done in this case. So, Laura Owens has developed a scheme she frequently imposes on men she dates. Number 1, initial manipulation. Owens begins the relationships quickly, fostering dependency with rapid discussions of family and commitment. Within months, she falsely claims pregnancy, manipulating photographs and documents to lend credence to her narrative. The takeaway: Owens expertly creates emotional traps, setting the stage for deeper deceit. Yep. And she always has a feeling. And by day 11, voila, she's pregnant with twins. 2, crisis fabrication. Miscarriage, abortion, inpatient mental health care, cancer, and unaliving ideations. Following the initial deceit, Owens invents medical emergencies such as miscarriages, offering fake evidence like manipulated test results. She assumes false identities to bolster these claims, fabricating correspondence from supposed allies or medical professionals to strengthen her lies. This step illustrates meticulous crafting of fabricated crisis to deepen her emotional control. See footnote 2. With Mike Marraccini, she claimed multiple miscarriages and abortions in 2016 through 2017, while claiming to be pregnant with twins. With Clayton Echard, she produced falsified ultrasound images and claimed to be pregnant with twins. She also did that with Greg Gillespie. Number 3, false allegations. Owens then escalates by falsely accusing her partners of abuse, presenting unsubstantiated claims of assault and harassment. This includes submitting forged records and photographs as false evidence. Publicly posing as a victim allows her to promote her false narrative. In each instance, evidence contradicts her claims. as courts have often dismissed her lawsuits and noted her lack of credibility. The pattern demonstrates her consistent use of deceit as a means to manipulate those who dare reject her. 4. Assuming the identity of fake people. Ooh, what do you have here? What do you have? What do you have? Okay. Owens assumes the identity of aliases or real individuals to support her conjured crisis. For example, Dr. John C. K. Chan is an actual medical professional for whom Owens authored forged medical letters purporting to be from Dr. Chan, a gynecologic oncologist, stating she had ovarian cancer and urging her partner to be supportive. Exhibit G, forged letter by Laura Owens purporting to be Dr. Chan. She forged notes from Dr. Rebecca Yee, Exhibit H, forged letter by Laura Owens purported to be Dr. Yee. Owens faked communications from entertainment manager David Katz in an attempt to mislead Marraccini into thinking Mr. Katz would represent him in his podcast venture with Owens. Owens claimed to have friends and associates who supported her story of being pregnant with twins. The court later found these claims unsubstantiated. Exhibit E, findings after the trial, Judge Mata, Maricopa County Superior Court of Arizona. Okay, so I am hoping that Omar has talked to Rebecca Yee and Dr. Chan, and they were like, we didn't send that. Like, we don't have anything to do with that. Because that would be great. And I hope he does, because he's saying that they are forged by Laura. Not that they believed that they're forged. I want the tea. Number 5. Forged medical records and injury photos. To bolster her lies, Owens fabricates documents and recycles unrelated injuries as abuse evidence. See footnote 3 and 4. Footnote 3 says Owens attached a forged letter purporting to be from Dr. John C. K. Chan, trying to convince Marraccini that she had cancer. Footnote 4, with Marraccini, she submitted photos of bruises from horseback riding accidents, claiming that they were caused by abuse. She also sent him a photograph of what appeared to be a positive pregnancy test. With others, she submitted videos of ultrasounds purporting them to be genuine evidence of pregnancy, when in fact the ultrasounds belonged to her sister. Right. Over a 10-year span, Owens manufactured medical proofs, quote unquote, to prop false narratives, forging an oncology letter, Dr. Chan, claiming an oophorectomy and surgical abortion via purported notes, Rebecca Yee, MD, see footnote 5. Laura Owens falsely used Dr. Rebecca Yee's name, a real physician, in 2016 to lend credibility to fabricated medical crisis, including alleged pregnancy complication. There is no evidence that Dr. Yee corroborated Owens' claims. Texting HCG and oncology materials, and rebranding horsefall injuries as domestic violence bruises, and Arizona, investigators found that she altered an ultrasound image and fabricated a pregnancy video, and filings show she submitted false medical records to her own expert. A judge concluded she knowingly presented false claim that she and referred her for prosecution, now charged with fraud, forgery, perjury, and evidence tampering. Together, these items form a continuous pattern of medical evidence fakery used to mislead partners and courts. 6. Restraining orders. Over the past decade, Laura Owens has repeatedly presented herself as a victim of abuse, alleging physical assault, sexual assault, or SA, stalking, and pregnancy-related coercion by numerous men. In each known instance, however, her claims that have been unsubstantiated, contradicted by evidence, or proven to be false outright. Courts have dismissed her lawsuits and, in the most egregious case, found that Owens fabricated evidence and lied under oath. Owens often makes such accusations reactively. Example, after a breakup or after the other party seeks help or legal action against her. And she frequently invokes false pregnancies or health crises as part of the narrative. In several cases, Mike Marraccini in 2018, Greg Gillespie in 2021, and Clayton Echard 2023. Obtained or attempted protective orders against the men only after they sought to distance themselves or took legal action against her. 7. Public victim narratives. Owens then uses the existence of a DVRO or court filings to promote herself as a survivor in public forums, TED Talks, essays, podcasts, attempting to garner sympathy and credibility while vilifying her former partner. 8. Collapse of the fraud. Over time, her fabrications unraveled under scrutiny. Independent courts and law enforcement eventually found her claims to be baseless, leading to dismissals, findings of fraud, and most recently, felony indictments for perjury, forgery, and fraudulent schemes. It was impossible for Marraccini to have understood at the time that he was dealing with a serial fraud. Corroboration that Laura Owens is a criminal. Okay, Owens. Thank you. Not Owens. Oh my gosh. I am so sorry. Please forgive me. Omar. Omar is saying it here in black and white. Corroboration that Laura Owens is a criminal. Owens pursued a paternity claim in Arizona against a public figure, former reality TV bachelor, claiming she was pregnant with twins, only to have those claims exposed as elaborate fabrications. The Arizona judge, after a full evidentiary hearing, found Owens' testimony to be woefully not credible, describing her claims as unreasonable and without basis or merit. And he cites to his exhibit of Mata's ruling. The court noted that Owens had presented a false claim and falsified evidence and accused her of wasting the court's time with her lies. In fact, the Arizona judge was so alarmed by Owens' conduct that she referred the matter to prosecutors, observing that Owens appeared to have a pattern of similar fraudulent behavior in court. A grand jury thereafter indicted Owens on the 7 felony counts. The indictment charges Owens with fraudulent schemes, forgery, 4 counts of perjury, and tampering with physical evidence, Investigators found that Owens went to extreme lengths to manipulate the legal process. She allegedly altered ultrasound images, fabricated pregnancy videos, and lied repeatedly under oath in the Arizona case. Oh my gosh. If we, I would have loved to see the grand jurors' faces when they're like, this bitch did what? This is crazy. Like, no, straight to jail. Lock her up and throw away the key. No. Like, they were probably gobsmacked. They won't be able to ever talk about it because sadly, grand jurors have to keep their stories to themselves. They don't really ever get to talk. These are not mere allegations by Marraccini. They are findings and charges by courts and law enforcement authorities demonstrating Owen's propensity to lie to courts and manufacture evidence to achieve her ends. Corroboration of Owen's fraudulent conduct constitutes extrinsic fraud. Marraccini's discovery of Owen's fraudulent conduct in subsequent legal proceedings constitutes extrinsic fraud. California courts have consistently held that extrinsic fraud justifies equitable relief from a judgment or order even after the expiration of 6 month period. Here, Owen's pattern of deceit, as documented in Arizona court findings and her subsequent indictment, demonstrates that she engaged in a scheme to manipulate the legal system and fabricate allegations against Marraccini. This conduct prevented Marraccini from fully litigating the 2018 DVRO. As he had no way of knowing Owen's misconduct amounted to fraudulent scheme to harass and stalk him for the duration of the order, or that she would continue this conduct indefinitely. This was bigger than the mischaracterization of photos, he said, she said, and a little minor perjury. Oh my gosh. Megan Fox is going to love that. Just a little minor perjury. This was the concealment of a full-on fraudulent artifice, ripe with false medical evidence, false communications, a concerted emotional harassment manipulation campaign, and a concerted effort to ruin Marraccini's life. Under California's three-part test, Marraccini must show 1. A meritorious defense, 2. A satisfactory excuse for not presenting a defense in the first place, and 3. Diligence in seeking to set aside the judgment once discovered. Number 1. Meritorious defense. To satisfy this element, the movement must demonstrate facts indicating that a different result would have been reached if the case had been defended. For example, in People versus One Parcel of Land. Okay, I'm kind of liking that. One parcel of land. Not two parcels, just one parcel of land. The defendant showed a meritorious defense by declaring she did not knowingly allow drug trafficking on her property. Well, God, I hope not. Not on just the one parcel of land. We did not approve that on our one parcel of land. It's only one parcel. Like maybe if we had two parcels, we would allow it, but not on this one parcel of land. Similarly, in County of LA versus Warmoth, DNA evidence was cited as potentially satisfying the meritorious defense requirement if accurate. Okay. Marraccini's defense is that Owen's abuse allegations were false, fabricated from whole cloth. Substantial new information or evidence now confirms that Owens is a serial liar who weaponizes false allegations, positioning herself as a victim to torment men who have no interest in dating her. Had Marraccini been able to present new evidence of Owens' fraudulent scheme, such as the criminal indictment and findings by other courts that anything Owens claims cannot be trusted, including Judge Monda's finding, it is highly probable that no reasonable court could have issued the DVRO. The evidence suggested that the likelihood of the different outcomes was significantly high. If the court had the opportunity to learn the full meritorious scope of Owen's claims, there would have been a different result, satisfying the meritorious defense requirements. I don't like that word, meritorious. 2. Valid excuse for not presenting a defense. The movement must provide a satisfactory explanation for failing to present a defense in the original action. In the People versus One Parcel of Land, the defendant's attorney misconduct, including failing to oppose the default judgment and not returning calls, was deemed a valid excuse. California courts have emphasized that the excuse must rise to the level of excusable neglect or positive misconduct as opposed to mere inexcusable neglect. Extrinsic fraud typically exists where a party is deprived of his opportunity to present his claim or defense to the court, kept in ignorance of the true facts, or in other manner fraudulently prevented from fully participating in the proceeding. Marriage of Varner. That is exactly what occurred here. Owen's fraudulent conduct prevented a fair adversary hearing by inducing the court to decide the case on false information. Through perjured testimony and fabricated corroborating evidence, Owens misled the court and thwarted Marraccini's ability to challenge her claims at the evidentiary hearing. Marraccini had no way to expose Owens' lies at the time. The falsity of her testimony only came to light years later. Thus, unlike a mere case of extrinsic fraud, example perjury, that could have been exposed at trial, Owens' actions amounted to extrinsic fraud because they fraudulently prevented Marraccini from fully participating in the proceeding. Coon be coon. In essence, Owens schemed to rob Marraccini of any meaningful chance to present his defense, which is precisely the kind of injustice California courts will not tolerate. And I think a good point of something that, Marraccini didn't know up until recently was her cancer claim, her ovary removal, and stuff, because she didn't say until Eckerd's case that she never had an ovary removed and that she doesn't have cancer. And Marraccini was like, well, then why the fuck did you tell me that back in the day when we were dating? So it wasn't till recently that Marraccini even found out through Laura's own admission that she lied about cancer and an ovary removal. He didn't know that before now. So, that's something Marraccini couldn't have defended because he was like, well, she had this. And he didn't. Most people don't lie about that shit. And besides the fact that women like Owens doing shit like this to men pisses me off because I have a son who a crazy girl has tried to do things to him. So it really irks my ass. But the three things, and I've said this before, that I think are the most horrendous things you could ever lie about is an SA claim, grape, ARPing, all that. Claiming that happened to you when it did not. Lying about having cancer. And lying to people about you being pregnant. I don't even find it funny on April Fool's Day. And Owens has done all three of those. The worst lies you could tell. She can go to hell. Because who does that? She does not give a shit. Continuing on. 3. Diligence in seeking relief. The movement must act promptly upon discovering the fraud or mistake. In People versus One Parcel of Land, the defendant demonstrated diligence by securing new counsel and filing for relief within a month of discovering the default. People v. One Parcel of Land, courts have stressed that a lack of diligence can bar equitable relief, as seen in Friedman v. Pack Gas and Electric Company, where a delay of nearly 3 years was deemed insufficiently diligent. Marraccini satisfies this standard. The record shows that Owens' fraud remained well concealed until recently. It was only through later developments, including documentation of her perjury and falsified evidence, that Marraccini discovered the depth of Owens' deception. Marraccini did not sleep on his rights after this discovery. To the contrary, he acted with appropriate diligence. May 2025, Owens was indicted. July 10th, Owens filed a request to renew the DVRO. September 11th, 2025, Marraccini responded by filing this motion to vacate following a thorough investigation into Owens' deceitful conduct, which I want to learn more about this investigation and what was found. Through these actions, Marraccini has demonstrated reasonable diligence in seeking relief after discovering Owens' fraud. There has been no prejudice to Owens in the timing as she sought renewal of the 2018 DVRO prior to this filing in July 2025. This was after her criminal indictment in May of 2025. Marraccini brings this motion a little over a month after Owens' request to renew, and after he substantially replied to Owens' allegations and after new investigation into layers of deceit that he's suffered now for nearly a decade. Owens' fraudulent conduct undermines the legitimacy of the DVRO. Relief is right here. To leave the 2018 DVRO is to bless a fraud on the court. The order was intended to protect genuine victims, not to arm a liar. Owens used it to sell her false story of being a survivor. The lie stains the law and weakens faith in it. The courts have stated that they will not allow their orders to be used as tools of deceit. When fraud wins an order, the court has the power to strip it away. Kolchar versus Kolchar. There is now strong evidence that Owens won the DVRO on a lie. The order was made without any finding of abuse. Her deceit is plain. To maintain the order would be to perpetuate the fraud. It would allow her to use the court seal to pose as a victim, to tarnish Marraccini's name, and to twist the truth. The courts of California have the power to stop this. In Oliveira versus Grace, the court stated that the equity may strike a judgment when the need for justice outweighs the pull of finality. This is such a case. In the marriage of Park, the court said fraud that keeps a man from a fair hearing is enough to open a closed case. Finality does not save a lie. Owens used the DVRO to dress her falsehoods in law. That abuse tips the scales. The court must guard the truth of its orders. That weighs far more than Owens' thin claim to an order won by fraud. Relief here serves the purpose of the law. The DVPA was made to protect the truth. It was made so that the courts could believe those in need. When Owens lied, she broke that trust. She hurt Marraccini, and she hurt real victims who come in fear and in honesty. I had a comment on a video recently that I am going to do a short on expressing my views, and it has to do with real victims and women. So be on the lookout for that coming out. To strike the order is to say the law is for protection, not revenge or vanity. To leave it is to reward her lies and punish a man who did no wrong. That cannot stand. Relief is necessary to prevent further misuse of the DVRO. The 2018 order must be struck. If it stands, Owens will continue to use it to harm Marraccini and possibly others. To leave it is to reward her lies. It would give her leave to twist the courts again. The Arizona courts saw it. Her pattern of false claims. Marraccini was likely one of the first. The law cannot be bent to serve such deceit. For Marraccini, the order still cuts deep. A DVRO carries weight. It brands a man. It does. And it has followed him ever since she's pulled this shit. So, kind of the question is, Arizona saw the pattern and the falsities. Will California see these falsehoods and these lies? And an even better question is, what is California going to do about it? Because Arizona said absolutely not. You will not do this stuff in our state under our courts. Will California follow in Arizona's footsteps? It follows him professionally in his right to hold a gun in his name. Each time he has to fly, TSA pulls him aside. They take him to a small room. They question him, sometimes for hours. They treat him as if he were a criminal. Yet no court has ever found he did wrong. I am so sorry, Mike, that you have had to go through that for 7 years. That is despicable. I mean, great for actual people that deserve to have a DVRO, but horrible to deal with when you didn't do anything and somebody just lied on your name. Justice calls for Marraccini's name to be cleared. The order was born of fraud. Lifting it now harms no one. Yeah, I don't think it harms Owens per se because she won't have this protection. She didn't need the protection in the first place. So she's not going to be harmed and nobody else will be because lifting it is not going to be what harms her. Her own lies is going to be what harms her. Her behaviors and her actions are what harm her. Nobody else. The relation ended long ago. Marraccini lives in California. Owens went to Arizona. She chased other lawsuits. She ran her fraudulent schemes on others. Whenever or whatever need she claimed in 2018 was never real. There was no cause then. There is none now. Marraccini has moved on. He has a wife, 2 children, and a life of his own. Thank God. He has an amazing wife who loves him, who knows that the man that Marraccini's ex, Laura Owens, portrays him as is not true. It is a life Owens wanted but could never have. She will never have it if she keeps this shit up. She should not matter to him now. She should be nothing. A sour memory fading in the sun of what he has built. The courts holds the chance to end this, to strike down the wrong, to guard others from the reach of Owens and her predatory ways. Yeah, because I mean, she has very predatory behavior. Such as I'll talk to him if he wants to talk to me, or hey, I'm in California, so let me stop off at his place of employment and talk to human resources and be like, did you know you had a guy working for you that I have a restraining order against? And I've had it for like 7 years. Ma'am, good for you. Get the fuck out. We do not give a shit. Because guess what? If they did a background check on him, they already knew this. And if they didn't know it for some reason because they didn't do a background check, now you've possibly cost him a job. Enough is enough. Like, you are going out of your way to figure this shit out. Information you shouldn't even have. Sanctions are warranted under Family Code 271. Respondent seeks sanctions award of the entirety of Mike's legal fees pursuant to Family Code 271 for attorney's fees and costs incurred due to petitioner's conduct in this litigation. This is not a Rule 26, David. So we're not Rule 26ing this. And there's going to be no safe harbor provisions on this one. All right. This filing serves as notice that the respondent will pursue sanctions based on petitioner's misuse of DVRO process, her fraudulent claims, and the unnecessary legal expenses her conduct has caused. By including this notice in the present motion, respondent satisfies the statute's procedural requirement that ensures petitioner has a fair opportunity to address the sanctions request. Respondent submits the court may rule on sanctions with the motion to vacate or, alternatively, defer the determination to later hearing after the DVRO is resolved, with this filing preserved as timely notice of respondent's intent to seek relief. Respondent further seeks sanctions under Family Code 271 in light of petitioner's conduct, which can be accurately described as a litigation ambush. Petitioner's actions in obtaining and litigating the DVRO have flagrantly violated the Family Code's policy favoring cooperation and settlement. This litigation ambush is characterized by petitioner's fraudulent and misleading behavior, marking a deliberate attack on judicial resources and fairness. Number 1. Fraudulently procured the DVRO. Petitioner obtained the restraining order through false and or misleading representations, effectively perpetrating a fraud on the court during this ambush. Number 2. Misled the court and abused the DVRO process. The petitioner presented misleading evidence and omitted testimony to maintain the DVRO, further exemplifying the ambush strategy that undermines the integrity of the proceedings. This misuse echoes the core purpose of Family Code 271, which penalizes tactics that price parties out of justice and discourage cooperation, emphasizing the need for fair proceedings. Forced unnecessary fees and litigation. By pursuing an unwarranted DVRO, petitioner has turned this ambush into a costly affair, compelling respondent to incur substantial attorney's fees and costs to defend against the order and now to seek its dismissal. The misconduct has escalated the conflict, prevented early settlement, and imposed unnecessary litigation expenses on respondent. Such conduct is exactly what Family Code 271 is meant to deter. Section 271 allows the court to award attorney's fees and costs as sanction based on conduct that furthers or frustrates the law policy to promote settlement and reduce litigation costs by encouraging cooperation in family law cases. Here, petitioners' bad faith tactics executed under the guise of litigation ambush have clearly frustrated the policy of the law by undermining settlement and increasing costs, triggering 271's applicability. Sanctions must be scaled to the payer's ability to pay and must consider the financially circumstances of both parties. Sanctions under California Family Code 271 must not impose an unreasonable financial burden. The court has a duty and the authority to impose sanctions for the conduct that frustrates settlement or increases litigation costs aligning with the policy goals of California Family Code 271. However, it is important to note that 271 does not require the conduct to rise to the level of bad faith or frivolousness, as required under the statutes like CCP 128.5. Instead, it focuses on whether the conduct frustrates the policy of promoting settlement and reducing litigation costs. California courts have consistently imposed monetary sanctions under 271 and its predecessor statutes in response to similar bad faith litigation tactics and abuse of the judicial process. For instance, in Remarriage of Battenberg, the Court of Appeals upheld sanctions against a party who pursued a bogus spousal abuse claim. A spouse's deliberate delaying tactics and bad faith conduct during the divorce proceeding justified $15,000 in attorney's fees awarded as a sanction. Reprehensible conduct falling short of bad faith can warrant fee sanctions under the family law statutes. These authorities make clear that courts will award attorney's fees as sanctions, whereas here, a party has acted in bad faith or engaged in litigation abuse toward the policy of amicable resolution of and fair dealing. In this case, respondent asserts the petitioner's conduct is more serious than the examples cited above. By allegedly creating false basis for a DVRO and requiring respondent to incur significant legal expenses, petitioner has increased costs and utilized court resources. This is the type of delay and expense that 271 is intended to prevent. Respondent respectfully requests that the court order the petitioner to pay respondent's reasonable attorney's fees and costs resulting from this conduct as permitted under Family Code 271. The Court of Appeal has clarified that 271 sanctions must correspond to the actual attorney's fees and costs caused by the conduct. The requested sanctions seek only those actual fees and expenses incurred due to petitioner's alleged misuse of the DVRO process. Awarding these fees and costs will compensate respondent and help deter future misuse of the court system. If the court does not grant sanctions immediately, the respondent requests that the court defer deciding on the 271 sanctions until after the DVRO motion is resolved, thereby keeping the issue open for a later hearing. Waiting would let the court fully consider petitioner's responsibility for respondent's fees after the DVRO is addressed. This would protect respondent's right and relief under 271 and let the court focus on the DVRO first. Still, because of clear litigation abuse and 271's focus on prompt action, respondent believes a sanctioned award now is justified. Respondent asks the court to grant the requested fees and cost to ease the financial impact of petitioner's actions and to discourage similar tactics in the future. This would support the policy of encouraging cooperation and help restore fairness as intended by Family Code 271, signed and respectfully submitted by Omar Serrato, attorney for respondent Marraccini, dated September 10th, 2025. Declaration in support of motion to dismiss DVRO pursuant to CCP 473B and D. Notice of intent to seek sanctions pursuant to 271. All right. And so this one is the declaration of Omar Serrato in support of the motion. And we have read many declarations. This is the first time, I believe, we're getting a declaration from Omar. Omar Serrato, the tilted lawyer, declares that he is an attorney duly licensed to practice before all courts of the state of California and counsel of record for respondent Mike Marraccini in this matter. I make this declaration based on my personal knowledge, my review of the court's file and documents and records maintained by firm's litigation file, publicly available court records, and evidence obtained in the course of my investigation. If called as a witness, I could and would competently testify to the facts stated herein. The declaration is submitted in support of respondents' concurrently filed motion to vacate the 2018 domestic violence restraining order pursuant to CCP 473D, the motion, and to provide notice of respondents' intent to seek sanctions under Family Code 271. The factual background, chronology, and legal grounds summarized below are the same as set forth in the motion. For my review of the file and records in this case, petitioner applied for a DVRO on January 9, 2018. The court issued a temporary order on January 10, 2018, because the petitioner claimed necessitated immediate interim protection measures. Respondent filed a DVR or a DV-120 response on January 22, 2018. After continuances for discovery, the parties entered a stipulated DVRO on or about July 10, 2018 for 2 years without any findings that respondent committed domestic violence. This stipulation was significant because no evidence was presented, leaving the respondent defense unexamined. Petitioner sought renewal on July 10, 2020. On September 11, 2020, the court extended the DVRO to July 2025 because the renewal was uncontested, perpetuating the limitation on respondents' rights without fresh evidence of misconduct. Yeah, because really and truly, her extension, it never had an interaction between her and Marraccini ever in it. And so I hate that the second one was even and it was renewed, because not once did he go near her or Buttons. On or about July 10th, 2025, petitioner filed another request to renew. The renewal hearing is presently set for October 2025. Respondent opposed and now moves to vacate the underlying 2018 order based on extrinsic fraud and newly discovered evidence that was unavailable in 2018, which significantly as it challenges the order legitimacy. It's significant as it challenges the order's legitimacy. New evidence unavailable in 2018. Pattern of fabrication. Since entry of the stipulated order, substantial independent evidence had surfaced being directly on petitioner's credibility and her use of fabricated claims and evidence in related matters, including Arizona paternity action. After a trial in June 2024, Maricopa County Superior Court found petitioner's testimony not credible, characterized claim as fraudulent, identified a pattern of similar behavior, and ordered her to pay over $149,000 in fees. A grand jury indictment on or about May 25th, 2025, a Maricopa County grand jury returned an indictment charging petitioner with fraudulent schemes, perjury, multiple counts, forgery, and tampering with physical evidence arising from the Arizona matter. And then he's got that attached. Other corroborating materials include police reports, petitioner's own prior sworn statements, civil pleadings in Owens v. Gillespie, and documents evidencing forged medical letters and reused injury photos, all described in the motion and authenticated below. Diligence and timing. Respondent acted promptly once the evidence crystallized. May 2025, indictment returned. July 2025, petitioner filed renewal request. August 25th, 2025, respondent filed opposition. September 10th, 2025, respondent filed the present 473D motion supported by this declaration. In my professional judgment, this sentence reflects diligent and falls well within reasonable time principles that govern equitable relief for extrinsic fraud. For instance, referring to cases such as Rappelia v. Campbell, which emphasizes the necessity of acting within reasonable time once new evidence is available, and further supported by the decision in St. Paul Fire and Marine versus Weiner, which indicates the timeliness of such actions reinforce the sequence appropriateness. 2018 order was issued by stipulation without factual findings of abuse. First, a meritorious defense is established through the newly available evidence, judicial findings of fraud in a subsequent contested proceeding, and felony indictments which undermine the petitioner's credibility and reveal the pattern of fabricating evidence. Second, satisfactory excuse is presented since the extrinsic fraud prevented a fair adversarial hearing in 2018. Third, diligence is demonstrated as the respondent promptly moved to vacate the order and seek sanctions once the evidence surfaced. This aligned with the equitable principles warranting vacatur in equity. The motion details this showing and applies the Rappelia three-part test: meritorious, defense, satisfactory excuse, and diligence. Authentication. Words are hard, y'all. Forgive me. Authentication of exhibits, true and correct copies. In the ordinary course of my representation, I have obtained and maintained the following documents. Each is a true and correct copy of what it purports to be, and personally identifiers have been redacted, which is good. Props for doing that ahead of time. He did the redactions where they were appropriate. Then he has his exhibit list, A through H. Notice sanctions 271, consistent with Family Code 271. Respondent gives notice through the motion and this declaration of his intent to seek monetary sanctions in the amount of his reasonable attorney's fees and costs caused by petitioner's litigation conduct, including her misuse of the DVRO process and resulting unnecessary expense to respondent. Fee records and ability to pay information can be submitted in camera or by supplemental declaration at the court's direction. Based on the foregoing and the evidentiary records summarized above, I respectfully submit that because the 2018 DVRO was procured in an environment tainted by extrinsic fraud that denied respondent a fair adversarial process, and because the newly discovered independent evidence post-dating 2018, particularly in the Arizona court's findings and 2025 indictment, undermines the integrity of the order. Therefore, the equitable and statutory grounds set out in the motion justify vacating the 2018 DVRO and awarding 271 sanctions in an amount and manner the court deems just. So he's not asking for a particular amount of money. He's just saying, hey, judge, whatever you think feels right, let's go with that. And then he declares under penalty of perjury, under the laws of the state of California, the foregoing is true and correct. And he wrote it on September 10th, 2025, and it was respectfully submitted. So that is his declaration. Then we have attached, and we've gone over this in a previous video. I think it's the video that's currently down right now because of Gingras, but that in California, it seems that they have usually in a case where it's like an attorney versus a pro se litigant, they will have, like, judges will have the attorneys write an order so that the judge can sign it. So Omar is just like, hey, if you agree with this judge, here's my proposed order that you can just sign off on and adopt and make your order. So the judge doesn't have to go type up something. Like, here it is right here. You just have to sign and date it. So it says, the court, having considered respondent Michael Marraccini's motion to vacate the 2018 domestic violence restraining order pursuant to the Code of Civil Procedures, Section 47.3, 473B, and 473D, 47.3. I've probably been saying that quite a bit, but 473. The memorandum of points and authorities, declarations, supporting exhibits, and any arguments presented at hearing, and good cause appearing therefore, hereby orders as follows. Number 1, respondent's motion is granted. Number 2, the DVRO issued on January 10th, 2018, and the restraining order after hearing July 10th, 2018, in the case, are vacated in their entirety. All subsequent renewals of said restraining order, including the September 11, 2020 renewal extending the order through July 10, 2025, are likewise vacated as moot. The clerk of the court is directed to transmit a copy of this order to law enforcement for updates of the CLEAT system reflecting the restraining order and has been vacated by order of this court. Petitioner's pending July 10th, 2025 request to renew the restraining order is denied as moot. And then, if so ordered, and the judge can put the date and sign. Okay, so here is one of the exhibits, and these are some text messages. So it says, I've answered all your questions today and have asked you to get help. I told you, prove it with actions. I'm not going to keep talking more questions until I see you do something for me. And so this text is from December 11th, 2016. Marraccini also says, I'm tired of doing your merry-go-round and what you want you to get help. Owen says, just said that, and that she is going to check herself in and that she is on her way. So in December, she says she is on her way to the hospital to check herself in for a mental health evaluation and all of that, according to her texts. Marraccini later says, don't be scared and I'll see you when you get out. Because they're not really allowed visitors either during that assessment period. Owen says, I just met my family at the hospital, which for the psychiatric evaluation part and therapy part, that is not what any of this is about. And I don't think it actually happened, but that's what she told Marraccini. Okay. Moving on to December 13th. She says, I forgot to tell you that my therapist is wanting me to set aside time at the end of each day to focus on what I am grateful for. I'm so incredibly thankful for you and your care towards me. It's interesting because one of the things we talked about was quote, and how much anxiety I have had about that in our relationship. It really hit me over the head today. That just over this past weekend, you showed me that love. You showed me the love more than I have ever felt from any guy. It really got me emotional. I feel your feelings for me, and I didn't want you to think they went unnoticed. You were so wonderful and appreciated by me, and I promise to show you how lucky and proud I feel to be with you each day. My goal is to each moment with you and appreciate every baby step that eventually leads to the big ones. You deserve the world, and I am not just going to try. I am going to give it to you as a great partner you deserve. XOXO. All right. And then on the second page, this is a snippet of part of Laura Owen's declaration. He has the full one in the filing that you can go read for yourself, but we have gone over the declaration of Owens in this case and everything else. It is on the Mike Marraccini playlist that you can go check out. So in the declaration it says, released later that night after I calmed down and no longer felt I was a risk to myself. And then it says, to Mr. Marraccini's allegations in his declaration, I was never treated in an inpatient facility. My psychiatrist adjusted my medication after this. But you said you went to the hospital where it was inpatient because you kept having to remind him they're going to take away our phones. But when you say you were never treated there, well, thanks for being honest because we knew you were lying about it. But in her text message to Jan, it says, I followed what Ron told me to do to get her back home. This is Jan, or that was just Marraccini. This is now Jan. Hi, Mike. We wanted to thank you so much for what you did for us and Laura this weekend. You saved her, and we will be forever grateful to you. She is getting treated as an inpatient right now, and then will continue to be treated as an outpatient. Okay, so her mom says that she was inpatient, but Laura says she wasn't. Who is telling the truth and who is lying? Besides Laura. Okay. Let's see. They're going to change her medication. They put her on for anxiety. We would love to take you out to thank you later this week or the following if you're available. Does that work? We also know this took a big toll on your family this weekend, and we would love to take everyone out to the House of Prime Rib this holiday season if your mom and sister are in San Francisco. So Jan is trying to play all nice and buddy-buddy, like, oh, we can just invite everybody, and, I'm sorry for all this, and that your family is involved, and all that. Jan doesn't have an ounce of credibility either, and she is a liar. Maybe that's where Owens learned it from. Then here is a picture that Owens sent to Marraccini. This is Owens at one of her horse riding events where she fell off her horse. And some say this is what caused some of her bruising, and this type of stuff is what caused her seizures. Not an Uber crash, not somebody abusing her, her hobby. And then she twisted it into what she wanted it to be, depending on the case, because the story always changes about the seizures. So this video was sent to Marraccini on October 22nd, 2017, I believe. And Mike says, or sorry, May 10th, 2017. I was reading that wrong. Okay. It's late when I'm recording this, but I am trying to get it out. And then I'm going to go to bed after this because I am so tired. Anyways, he says, holy shit, was that you? And then she says, yes, just now. I'm really shaken up. I hope you know I just want to make sure you are sure you want to be with me. Like, what? Why is that what you're concerned about after falling off a horse? Hey, I fell off a horse, but I really want to make sure you really want to be with me. Ma'am, focus on what happened to you and how to get better instead of trying to make sure that your man wants to be with you. All right. And some things that I didn't include in here were Exhibit A, which was the paper for Marraccini's police report against Owens and the picture with the police outside the door. That was Exhibit A. Exhibit C was Owens' declaration in the Marraccini case from March 28th, 2018. We have gone over that in another video. I will link it in the description, or you can just go to the Marraccini playlist on my channel. Exhibit D had the photo of the horse, but it also had like information about her in those shows. Exhibit E was Mata's ruling, which we've gone over. Exhibit F was the felony indictment. We've also gone over that. And exhibits G and H are just the notes from Sutton Health from Dr. Chan and Dr. Yi, which we believe are forged, and Laura actually fabricated those, which we went over in the last motion and even the exhibits video as well, talking about what those letters say. And we've gone over them when we went over the Marraccini timeline as well. So those are all things we've done videos about, and I didn't think we needed to just go back over them. But they are available if you want to go review what those say. You can read the case filing and look at it in the filing, or you can go and watch the video on my playlist. But that is it for me, guys, and I will see you in the next one. Bye.